This is the time set for oral argument in 1 CA CV 160331 Rodriguez v. Wise. Counsel, each side is allotted 20 minutes for oral argument, and the appellant, if he wishes to reserve any time, that will be on you to follow the clock at the podium and reserve any time that you would like in rebuttal. Out of respect for counsel, I ask that those in attendance please turn off your cell phones or put them on vibrate. And counsel, we are recording this oral argument. It'll be posted on YouTube in short course. So before you begin your argument, please state your name and the party you represent. And also I'd like to let you know that we've read the briefs. We've conferenced this case this morning, so we encourage you to keep that in mind as you present your oral argument. So with that, I will start with counsel for the appellants. Mr. Robbins, go ahead.
Good morning, Your Honors. Christopher Robbins here on behalf of the defendants' appellants, Wise. I will attempt to reserve 5 minutes for rebuttal, whether that happens or not. I hope Your Honors find the case as interesting as the parties do, and it's actually stirred a lot of interest in the community as well. Because you're familiar with the facts, I would actually like to move backwards from the easiest reasons for reversing the sanctions order to those that are a little more difficult. So I'd like to start with Rule 37E. First, that rule permits an award of reasonable expenses, not sanctions, reasonable expenses, if the party requesting admissions proves the truth of the matter. There is no way that Mr. Rodriguez can prove the truth of any matter because the jury returned a general verdict of $100,000. That might have included all or part or none of the medical expenses, all or none or part of general damages for pain and suffering and inconvenience. There's no way to tell.
Are you saying that sanctions can never be imposed without a specific finding relating to a request for admission?
Not necessarily, Your Honor. I think we can think of situations. For example, if I requested a plaintiff point out a specific contractual provision that's allegedly breached in an insurance policy and they can't identify that, and if I get a defense verdict, then I think we know that that's part of the defense verdict. In this case, absolutely yes. They had a way to determine what medical bills were proved up by asking special interrogatories. It would have been as simple as just on the verdict form listing the various medical providers.
But don't we essentially know that by virtue of counsel's concession at the start of trial that we're really only disputing one or two expenses? So is there really any question that the jury found the other ones?
Oh, Your Honor, absolutely. We don't know what the jury found. That's in West versus Sundance, in Volan versus Farmers, in the law review from Judge Fidel, said you can't speculate about what the jury determined. The jury could have determined anything. I've had a number of cases with our Supreme Court where they basically said whatever the jury does is good with us. If it was their intent to pursue Rule 37E, reasonable expenses, then the solution was to have special interrogatories before the jury so the jury could tell us exactly what they had proved up. Second, go on further in the rule. It says the court should award reasonable expenses unless, and then there are 4 exceptions and 2 apply here, unless the court held that the requests for admissions were objectionable or there was other good reason for the failure to admit. Twice in writing, the trial court said, upheld the objections submitted by defense counsel. Twice in writing. The judge did not say you need to admit the the request for admissions, did not say you need to go do this over again, did not do anything. She upheld the objections. Now, if the trial court had ordered defense counsel to admit the requests or had deemed the request for admissions admitted or had said go back and amend these responses, defense counsel could have complied and we wouldn't be here.
You're saying you can never impose sanctions. Do we have to find that the court incorrectly denied the request regarding the request for admissions? If we look at the request for admissions and say, yeah, there was nothing wrong with simply denying those, that you don't have to admit those prior to trial, you get to require the plaintiff to present their case to the jury, can there still not be a basis for sanctions based on an unwillingness to narrow the scope of the trial and to cause everyone to run up unnecessary expenses?
And that's a more difficult question, Your Honor. And it actually goes more to Rule 36 than Rule 37, I think. But in this case, the judge, a month before trial, said plaintiffs have the burden of proof of showing negligence, causation, and damages, basically upheld the objection that defense counsel had been making from day one. And here's the situation. They had worked themselves into a corner. They had not designated an expert, which almost always happens in these simple auto cases. The plaintiff designates an expert to talk about the reasonableness and necessity and causation. That didn't happen. They had backed themselves into a corner. Now, to get those medical records and bills into evidence, they needed to present something more than just the bills and records themselves. They needed to offer the testimony of at least one of their medical providers. Instead, they chose to go and take a videotape testimony of every one of their providers, including custodians of record, which had already been, the company had already stipulated to.
Didn't they have to do that because your client denied every element of damages that they had asserted, even after your client presumably had the medical records that indicate what was done, and from that point, your client was unwilling to stipulate to anything and to say, okay, these expenses are reasonable, we're challenging these expenses. At that point, don't they have to do the depositions? And isn't that what the court was focusing on here? You had all these records, and you didn't really seem to have taken issue with them, other than you said, oh, we're going to make you go through the effort of doing that at trial, but then it turns out you really didn't.
It's actually a very minor effort, Your Honor, because, as I said, in the typical case, I will tell you, I've got a partner who practices exactly like you just suggested. He attempts at every opportunity to stipulate to what can be stipulated to and not stipulate to other things. And that's the way I think most practitioners practice. You may have detected there was a clash of heads between the attorneys on this case. But having said that, plaintiff first must come forward with something, must come forward with an expert or some medical provider that says, these are reasonable and necessary, and then defense counsel has the right to cross-examine those. I mean, it may be that there's no cross-examination. It may be that ultimately, which is exactly what happened here, once that was done, counsel agreed that he would only contest 2 of the medical items.
But what was the point of going through depositions if you have all the medical records? I'm assuming with depositions, most doctors aren't going to have specific recollection, and the focus is going to be on what's in the records. Why put everyone through that exercise?
Part of the answer is that We don't have foundation.
You stipulated a foundation at some point before trial.
A foundation that they were kept in the regular course of business, not that they were reasonable and necessary and caused by the accident. We stipulated the foundational.
But you didn't really ask cross-examination questions that went to the reasonableness of most of the treatment.
It turned out that plaintiff was able to meet his burden of proof, and that's what trials are for. Plaintiff was able to meet his burden of proof, and once he did, then defense counsel said, "Okay,
but that really
I will
wasn't
still." But here's another thing. For example,
I don't think that's what your client's trial strategy was. You get to trial and say, "Well, we're really only disputing two things," which kind of suggests, gee, the other side's trying to make a big deal. We've really been reasonable all along. We're really only challenging two things, when you in fact had challenged everything up until opening statement. Can't the court look at that and say that's if that's really the case, and you had all these medical records ahead of time, you've wasted everybody's time and money?
But, for example, he spent $34,000 for one night in a hospital, $17,000 of it, which was diagnostic tests, which all proved negative. Is that reasonable? Is that necessary?
But you didn't challenge. You acknowledged at trial that the hospital stay was reasonable and necessary.
After they presented the trial testimony of their doctor.
Were you surprised by the testimony?
I wasn't in this trial, so am I surprised at that?
No.
I think a jury can say, even if the doctor said, yes, these are reasonable and necessary, I think a jury can say, you know what, this is ridiculous. $34,000 for one night and one day.
But that wasn't argued to the jury, as I understand. Your client conceded that.
Ultimately, defense counsel actively contested two items. For example, one of the items was a scan that occurred like 3 months after this accident.
When you're saying ultimately, my recollection was during opening statements, counsel had already narrowed it to that. Is that not accurate?
No, it was the second day of trial when the judge specifically asked him, when this issue arose again, specifically asked him.
What did counsel say during opening statements? Did he suggest that there was something that was disputed beyond these two items that were ultimately the ones that were being challenged?
I think he just disputed in general exactly what he had said in the amended answer, which is we're disputing the extent of causation and damages. And,
so you're saying the concession didn't come until after the hospital record had been admitted and there's a discussion about it?
The concession, as I understand it, came on the second day of trial when this issue was raised once again. But then my question to the court is that a discovery violation? Is that a discovery violation, or is that because he was just, he didn't as quickly admit or concede certain medical expenses?
Do we have to necessarily find that there's a discovery violation before the trial court can impose the sanctions?
Well, I think she said these are discovery violation sanctions. That was her order. These are discovery violation sanctions. There was no discovery violation in this case. And again, whether all of that is true or not, is she had twice before trial, when something could have been done, ruled that the objections are good, that you do not need to amend these responses. Twice before trial. We have to be able to rely upon a trial court's rulings. As a trial attorney, you have to be able to rely upon those rulings, and then to come afterwards when nothing can be done, when it's all passed and when it's all done. And so, again, returning to Rule 37E, what could be a better reason for denying the reasonable expenses than the fact that the judge has ruled in your favor twice.
Well, the judge has allowed you to challenge, but then it turns out you really weren't challenging much of anything. And so the judge is saying, well, given this just looks like you were just wasting everyone's time and money. You really weren't challenging them. You had those records, and you could have looked at them and reached the same conclusion.
Well, Your Honor, we're not medical doctors. Certainly, Mr. Wise is not a medical doctor. So do we have a different standard depending upon whether the defendant is insured or not? I mean, we can't have it. The rules have to apply uniformly. And so Dr. Wise has no foundation whatsoever to say whether, Mr. Rodriguez's medical records were kept in the regular course of business and whether his medical records were reasonable and necessary. Mr. Wise could have answered things about the accident, which is what I think a Rule 36 request should be. And I will actually talk about that in one moment, but very quickly, because I see I'm running out of time, they didn't prove up, they did not request fees for proving up the truth of the matter. If you look at Mr. Fidel's affidavit, it specifically says, I'm not requesting anything for trial. They requested everything, their fees for everything that happened before, but not for trial, which is where you would actually do the proving up. And what does the proving up take? They had to have somebody present evidence regarding the records and the bills, and that was the trial testimony. That was the videotaped trial testimony. They had to present that to win their case. They did. Congratulations. They won their case. But the proving up of the request for admissions was asking each of the medical providers one or two questions. Were they reasonable and necessary? And fourth, a sanction in the amount of $39,700, and I quote directly from the case, so far exceeds what is just and appropriate for the cited violation. That is a clear abuse of trial court discretion. That's the Taliafiero case. I will not belabor it. We talked about it at length.
If there were a sanction of $5,000, that would be okay here?
I'm saying it has to be something within reason. If there's a violation here at all, and I deny that there's a violation, if there's a violation, it's certainly not $39,700. I cannot find any case that has anything even remotely similar.
Wouldn't we defer to
Mr. Rodriguez did not.
Wouldn't we defer to the Superior Court's assessment of that, though?
No, the Taliafiero said no. No, you cannot defer to it. It's so grossly excessive that you cannot defer to that.
Why is it grossly excessive? If it just tracks work that would not have been done if your client, after looking at all the medical records and reaching the conclusion that you weren't going to challenge anything, had just agreed to go forward without putting everyone through the expense of that. It seems like there is some relation to the number the court came up with.
So then defendant has to concede the case, essentially.
If the defense looks and has all these medical records, and if you're not, and then the court looks and says, you conducted a bunch of depositions, but you didn't ask any questions, you didn't really dispute something, isn't it within the discretion of the Superior Court to say, I think this was just a tactic that didn't further the case at all? I might agree with you that I might not have imposed those, but can we necessarily say that that's outside the discretion of the Superior Court?
Absolutely, under Taliafiero. Absolutely. They said it's an abuse of discretion for a much smaller, for a much greater offense and a much smaller amount. They said that is a gross abuse of discretion. Just very quickly, under Rule 36, there are procedures that are followed. You have to admit or deny. He denied. He didn't hem and haw. He didn't say, I can't answer this. I don't know. I'm going to refer you to something else. He denied the claims. At that point, the requesting party can question the answers, the sufficiency of the answers or the objections. That's exactly what they did. At that point, the judge has to either say, I affirm the objections and the responses, or can order the matter admitted or amend the answer. But again, it has to, under Rule 36, the express language, it has to be done before trial. It can't wait until after trial. If they had done it before trial, it could have been corrected. We wouldn't be here. And finally, I don't think you have to actually look at Rule 36A and what's a good request for admission and what's not, and what's a good response and what's not. But the trial litigators in the state would be very happy if you could offer any guidance. It doesn't affect this particular case, but they'd be very happy if you offered guidance. And I've completely run out of time, so I will sit down, Your Honors.
Thank you, counsel. Mr. Fidel, go ahead.
Good morning, Your Honors. Nathan Fidel for Plaintiff Jesus Franco Rodriguez. With me is Nathan Webb as well. What I've been hearing all along in this case is that the issue should be, can the defendant who has no reasonable basis to contest damages in a case and made no reasonable inquiry simply require the plaintiff to do all the work in the case? No reasonable basis, no reasonable inquiry. Those are key words. The answer is no. Throughout the rules of civil procedure.
At what point are you suggesting counsel was obligated to say, I concede that this expense is reasonable?
They should, at least in their initial disclosures, start out by stating what the factual basis for their defense is, according to Rule 26.1, certainly by the conclusion of discovery. If they have no reasonable basis, because discovery is the setup for civil attorneys to inquire.
But at the conclusion of discovery, so after all the depositions have been taken, so how would that have changed things here? Those expenses have been incurred, and so if at that point they say, and we're 2 weeks before trial, and they say, we are only disputing Bill A and Bill B, two expenses that have been asserted, is there any basis for sanctions there?
Sure, because there is a dispositive motion deadline. There is a discovery deadline that was set earlier in the case. And so throughout the rules.
But this is after discovery. I mean, do you have an obligation to concede something before discovery is complete?
You have an obligation to concede if you've got no defense as soon as you find out you don't have that defense.
But what I'm suggesting is you find out during the deposition that, okay, this guy is credible, he's going to be able to make the case. Why should I be sanctioned for the cost of that deposition? I did it. Once that's over, and I'm hypothesizing now, discovery is completed yesterday. Today, I'm going to send a letter saying my client disputes 2 expenses only, and we're just going to argue that the jury shouldn't come in with a verdict over whatever the amount. Is there anything sanctionable about that?
If the timeline that you've described takes place and the plaintiff, by the close of the court-ordered discovery deadline, has not inquired about what your defense is.
Well, but I'm saying discovery deadline was over yesterday, and now I submit something and say, okay, this is what we're going to challenge. Based on the discovery, this is what I now believe is worth challenging at trial.
In this case, the discovery deadline expired before the depositions. What you're asking about in this hypothetical, if the defense takes that step, they've noticed the deposition, they've found out through their reasonable inquiry that there is no defense, right? They made a reasonable inquiry, then at that point that's fine. But the case in front of you, there's no reasonable inquiry that has ever been made. The defense did not inquire of the doctors by the rules that permit them to do so. The defense did not.
What's your response to their argument that you didn't have an expert that was going to come in and say everything was reasonable?
Look, I would think for most of the people sitting in this courtroom, certainly in this court, you have a state-sponsored insurance plan. You have the ability to have a primary care physician. Poor people don't have primary care physicians. Okay? They go to the hospital, to the ER when they're hurt. They go to the urgent care when
But now
they're
we're talking about an expert that their counsel would arrange for. I'm not relying on them just having a doctor that they can bring
The
in.
defense has put forward a hypothetical to you all saying, in most cases, the plaintiff has one provider or one expert who can review all the medical records and testify about the necessity of those medical records. That's right when you have a primary care physician. In an instance where you don't, where you're poor, and you go to a hospital, for example, you go to an urgent care. When you're sick, that's when you go. It's not like I can go to a treating physician and say, review all of these records, even though you've never seen them before, and offer me an opinion. That's not realistic. I called the treating providers because they have knowledge about their own records.
But you could call an expert. I mean, there's nothing that keeps you from calling an expert,
And
right?
so I suppose then the court would be requiring a plaintiff to not use their treating physicians who actually have a fundamental understanding of the treatment they provided, but rather, because the defendant so requires, call other individuals who review the case, pay them.
But I'm just having a hard time getting over the hurdle of it seems like deposing the doctors is necessary. If I'm defending a case, I'm not going to just concede just because the plaintiff says I've seen 5 doctors. I need to hear from the doctors. Admittedly, I've got the reports, and maybe I should do an inquiry there. But I come back to my question: if we go through this discovery, and I know you're saying discovery was already ended, although they're allowing some depositions, so I'm not sure I'm following that discovery is over. If we go through that discovery, the next day, defense counsel says, I'm only challenging 2 expenditures. In your view, which rule authorizes the imposition of sanctions under that scenario?
Rule 11, because I noticed the depositions. It wasn't their reasonable inquiry.
Which rule did the court rely on here?
The court relied on violations of Rule 1, Rule 11, Rule 26B, Rule 26F, Rule 26B, 26.1B2, Rule 36A, Rule 37C, Rule 37E. Arizona...
And didn't segregate out. It lists all the rules and just saying these are the sanctions.
If the court would like a segregation out, you can look at in the index of record in my reply brief. It's, I believe, 121 through 122, where it lists each of the specific violations. And don't forget, Arizona revised statute 12-349. It's a nice catch-all. 1 through 4, every single one of them is violated. There was no reasonable inquiry. When you sign your name to a brief as an attorney, it indicates that you have made a reasonable inquiry under Rule 11.
But where are you saying? Because I'm not having. I'm not really finding anything wrong with the answers to the request for admissions. So I don't think you've signed your name to something. Just assume that. I might be persuaded otherwise, but is there something? Is there a basis for imposing sanctions after that, where and maybe you're just suggesting under Rule 11 or others where okay, those were your answers to the request for admissions, but beyond that, now you've had a chance to look at medical records. You don't. You really, and now that I've gone through trial, I see that you really didn't challenge any of those. In your view, which rules are most applicable to imposing
Well, I think I've
sanctions?
listed them. All of them get to this basic fundamental idea that runs throughout the course of our discovery rules and our ethical rules. And 3.1 and 3.2 were brought to the trial court's attention in the underlying case as well. Don't waste everybody's time. Only bring issues that you have made a reasonable inquiry into, and you have a factual basis to challenge. Disclose it. If I've got a problem in the case, I want to be able to talk with opposing counsel about the problems in the case. I don't want to talk about frivolous stuff. My time is worthwhile to me. My client's time is worthwhile to me. The court, every trial court, states, don't burden us with discovery disputes. Please try to resolve it amongst yourselves.
But this isn't necessarily a discovery dispute we're talking about. We're talking about how serious an injury was. We don't dispute that the medical bill was for $39,000 or $24,000, whatever it was, what each individual bill is. What is it that you want plaintiff or defense counsel to concede if they're going to challenge the overall amount that should be awarded your client? In your view, the appropriate course of conduct for defense counsel is what?
The appropriate course of conduct is in your 26.1 factual disclosure. First, state, as 20.6.1 recommends and requires actually, state the factual basis for your defense. If you're going to dispute the medical records, tell me what's wrong with the medical treatment. Okay? If you are going to, thereafter, if you have a basis, fine, let's get to the bottom of it. We can do discovery. We can find out if the medical treatment that you're disputing is reasonable and necessary. But don't play games. We know that, and they know, that the medical treatment, for example, we gave the example of the ambulance bill. They disputed the ambulance bill up until the second day of trial. They had no basis to do so. Even when I took depositions for some of these physicians, there was not a single question that was asked on cross-examination. If that's not an admission right there that there is no factual basis to dispute, they didn't even make a reasonable inquiry. That's a discovery violation. The discovery violation starts the minute that you file your answer. It indicates as an attorney that you're going to make a reasonable inquiry into this case. The minute you file your disclosure, you have to state the factual basis for your defense. If then, as the plaintiff, I take on the burden to inquire because you haven't done your job and send out requests for admissions to understand what's going on, which is what I did, and you still can't answer it, then there's a problem there. This all along has been a discovery violation case. The problem was that it took until trial for the judge to actually put it to the defense in oral argument and say, tell me, really, what is it that you're disputing? Because the defense lawyer refused to do that. That's the violation. It runs afoul of all of the rules. And as soon as she figured it out, as soon as she figured out that he had no factual basis at all to dispute these records, the sanctions became apparent. There's 12-349 ARS permits sanctions for a dispute, for a conclusion that the dispute was gamesmanship. Their admission shows that this was gamesmanship. They had no factual basis. They have not been able to cite anywhere in the underlying record to briefs in front of this court of a factual basis. And really, what this case is about is a practice of law that Robert Eamon had been doing for some time.
I'm not as interested in a course of conduct. Trying to figure out in this one, and I apologize for just belaboring this, but in your view, and I'm just talking hypothetically, if defense counsel just says, I want to hear from everybody before I admit anything. These bills seem a little bit high. I hear from them. I don't really cross-examine them much, but I've taken those depositions. The very next day, I say, we're going to challenge 2 bills. Has there been any kind of a discovery violation under that scenario?
Yes. First, they didn't do that. They never said these bills seem a little bit too high. Okay, but
if just under my hypothetical, is there a discovery violation?
Right. Yes, because you have to tell me the factual basis that you believe the bills are a little bit too high.
They just seem high to me.
You got to tell me the factual basis. You have to make reasonable inquiry. That's what the
Isn't
rules
my
say.
reasonable inquiry, I'm going to interview these people?
Not I'm going to, I did. You have to make reasonable inquiry, or you have to disclose what your reasonable inquiry was. Earlier, you stated that their request for admissions responses were okay. They are not okay. They cite to Larson v. Decker, and it's a misunderstanding of the case, a fundamental misunderstanding of the case that has been pervasive in the defense bar for some time now. They take a case that is cited by Larson v. Decker called Patterson. It's a Washington case, and the defense bar has been expanding Patterson to fight every medical record. Patterson states that medical records alone, you can't get them into evidence under the business exceptions rule. Okay? That the medical record itself, even if it states causation, even if it states reasonableness, even if it is necessary, it doesn't come in. But Larson v. Decker does not hold that. It cites to Patterson as a CEG. And Patterson is what this case is about. Patterson is the attempt by Robert Eamon to expand the fight against plaintiffs. Here's what Larson v. Decker says, and this is the law that seems to be lost on the defense. It states in paragraph 5 that Decker disputed a contention between shoulder complaints and the auto accident because Larson had fallen on his left arm and hand in a bicycle accident and reported shoulder pain before the auto accident. There was a disclosure of the factual basis of the contention. There was a previous incident that they were pointing to. We never knew what the factual basis was here. There's more. They disputed that the accident had aggravated a prior hip injury. They were pointing to a private hip injury. They were pointing to previous medical records. Again, there is no disclosure in this case whatsoever of the basis for challenging it. Had they said, Mr. Rodriguez had these issues in his records.
Do we have to find that there was a violation, that the answers to the request for admissions were improper in order to uphold sanctions?
I think it starts there. You don't necessarily need to, but I think going back there, you should look at those.
So because I have looked at those requests for admissions, and it does seem to me that it's, I will look at them again, but it didn't jump out at me that they were necessarily a violation of any kind of ethical duty to look at those. If you're asking for concessions that go beyond, this is the amount of the medical bill. If that's your request for admission, that's one thing. But my recollection is that the requests for admissions go beyond admit that the hospital bill was $19,000. Am I misremembering that?
There was not a specific amount that was provided. It said admit that the medical bills were reasonable, necessary, and causally related. So not a specific amount, but rather it said those key words.
Well, and the causally related, I mean, that does seem to me to be asking for more than maybe necessary, or that it's somehow improper to deny that.
The request for admissions, according to West, you are permitted to ask questions that are based on fact, that we've cited it in our brief, from which you can draw a legal conclusion. It says that quite clearly. We were trying to find out if they had a factual basis to dispute the reasonableness and the necessity of medical treatment. I shouldn't have to ask that question. It should be affirmatively disclosed as 26.1 requires. Disclose the factual basis of your allegations and your defense. And I want to go back to Larson v. Decker. What seems to be forgotten in all of this is paragraph 19. They keep pointing to Patterson in paragraph 20. But look at paragraph 19. Whether business records are sufficiently reliable to satisfy the hearsay exception is for the trial court's sound discretion. To be relevant, however, medical records must be linked to the issues in the case. If the records and bills themselves do not establish the necessary connection, other evidence may be needed. The records in this case established the connection. The ambulance bill happened right after the collision. The hospital treatment happened right after the collision. The big fight here was that 80% of these bills happened within 24 hours, and not once for 2.5 years did I get, or for 2 years, did I get an answer as to why they're challenging it. What's wrong with these records? There's an affirmative duty. It runs throughout the rules. It's not just 26.1.
Are you talking about whether the records are legitimate, it's a business record, or that the overall amount was?
If they were reasonable and necessary and causally related. I asked whether the records were.
Counsel, before your time's up, Mr. Roberts brought up Talafiero, and can we, sitting in this court, kind of dive into, I mean, the amount is, I think we all agree the amount of sanctions is quite large, nearly $40,000. Does Talafiero, as Mr. Robbins states, give us the discretion to go in and review that to determine whether it is excessive?
It does not. I would submit that the trial court, according to Talafiero, is in the best position to do this. The trial court had all of my timesheets as well as my associates' timesheets, was well aware to make those decisions. I would also point the court to the U.S. Supreme Court decision, Goodyear Tire and Rubber versus Hager. It came out in 2017. We cited the Ninth Circuit decision in our briefs, but this is a new opinion, and it finds that the trial court is in the best position to make these decisions. Given that there were timesheets there, we think the judge had enough in front of her. It looks like I'm out of time. Thank you.
Thank you, counsel. Thank you for your briefs.
Your Honor, may I have 30 seconds?
All right. We'll give you a minute for rebuttal, counsel.
I'll actually try to be brief, Your Honors. There were no depositions of medical professionals or any type of medical people taken in this case. Long after the discovery period, Mr. Fidel took trial testimony, videotaped trial testimony from the medical providers in lieu of live testimony. Those were not depositions. That was trial testimony. That goes to our issues regarding the Rule 68 sanctions and taxable costs. And so I hope you will look at that closely. And we refer you to our briefs regarding the other non-taxable costs that were awarded in this case. Thank you, Your Honors.
Thank you. Counsel, thank you for your briefs and your argument today. Very well done. We'll take the matter under advisement, issue an order in due course. We'll now stand at recess to allow the next case to set up for the oral argument. Thank you.